The Supreme Court on Friday, in a judgment delivered, ordered the continuation of the trial of Nnamdi Kanu, leader of the indigenous people of Biafra IPOB, on terrorism charges. The case, which began in 2015, had been on hold at the Federal High Court in Abuja after the Court of Appeal dismissed the charges in a judgment delivered in October 2022. The Court of Appeal had anchored its decision dismissing the charges on the illegality of the extraordinary redention of Mr. Kanu from Kenya to Nigeria in June 2021 to continue his trial. A 5-member panel on the Supreme Court, led by Kudirat Kekere Eko, delayed on Friday that Mr. Kanu's forcible repatriation from Kenya to Nigeria is illegal. However, the court, in the lead judgment prepared by Tijani Abuba, ruled that there is no Nigerian law that prohibits the use of illegal obtained evidence for the trial defendants. The lead judgment of the Supreme Court was prepared by Mr. Abubakar but was read on his behalf by Emmanuel Ajim. The Court of Appeal was wrong to say that the Federal High Court can no longer try Mr. Kanu. The court held the appeal is allowed and the cross appeal is dismissed. The judgment implies an effective reversal of the previous decision of the Court of Appeal ordering the release of Mr. Kanu detention.
The Supreme Court knows better. The Supreme Court is the Supreme Court. What the Supreme Court says represents the law. We respect it. We go by it. There is no other way. We had hoped that it would come our way, but it has gone the other way. It simply means that we have to go back to the High Court and get done with this quickly. We still have hope. We are not in despair.
By the grace of God,
yes, so
victory is assured.
Yes,
at the end of the day.
We will lose a little time. We still have to go back. That's all it means. But I'm very consoled by what the Supreme Court said, that he ought not to have been treated the way he was treated. His bail ought not to have been revoked. His home ought to have been invaded. All that is a consolation to us. So we have.
It's indeed a very sad day today. If you looked at the judgment, the court showed empathy in the way the rendition was conducted, the torture, the treatment meted out to Mazi Nnamdi Kanu. It's just a technical matter, just like the counsels for Mazi Nnamdi Kanu has stated. I'm sure they are going back to the drawing board, starting again from the High Court all the way to the Supreme Court. The Supreme Court is sympathetic to the plight of Mazi Nnamdi Kanu, and I believe there's hope at the end of the tunnel. Thank you very much.
That's what happened today at the Supreme Court. If you ask me, I would say this is victory to our administration of criminal justice, because it shows that once you are an accused person, once you are a defendant, no matter what excuse you want to bring to hide under the law to say that you should not be tried, the Supreme Court have expressly, unequivocally stated clearly that we don't have the legislation that will vitiate the court from trying a defendant that has committed a crime. You must be tried for every offense you have committed. Exactly. Our laws have made very clear provision for remedy. Where there's such infraction on the right of the defendant, then you can such a defendant can go to the civil court and then seek for civil remedies for the violation of his fundamental rights. And that is why, of course, we have the fundamental rights enforcement, for which the defendant, the respondent, which is the defendant in this case, have actually activated. And you are aware that he has gone to the civil court and he has gotten some judgments, which is still subject of appeal, as to whether or not his fundamental rights have actually been infracted or infringed upon.
Thank you. Reporting from Nigeria's state capital, Soy Bifa, Jakarich, Top Accolade News.